Mr. Leday, would you please put your mic on mute? Okay. One minute. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence L. Holmes. I'm the residing judge here in County Court at Law Number 2. You have been asked to come to court this morning because you have a case here in County Court at Law Number 2. You have been asked to come for what is called an arraignment. An arraignment basically is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. Criminal cases are divided into felonies or misdemeanors. This court, County Court at Law Number 2, we only handle misdemeanor cases. Now, felony cases are your most serious type cases, and your misdemeanor offenses are normally referred to as petty offenses. Hold on a minute. Okay. Okay, now, ladies and gentlemen, as I was explaining earlier, you're here for what is called an arraignment. An arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Your case is a criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are handled in the district court. This is a county court at law number 2. We're not a district court. And so with the felony cases, they are referred to as your most serious type offenses. And they're divided into 5 categories. The highest category of felony is called a capital murder. The range of punishment for capital murder is, if you're convicted, is life or death. The next felony below the capital murder is a first-degree felony. The range of punishment for a first-degree felony is 5 to 99 years to life, a fine up to $10,000. Below the first-degree felony, you have a second-degree felony. The range of punishment for a second-degree felony is 2 to 20 years in the state penitentiary, a fine up to $10,000. Below the second-degree felony is a third-degree felony. And the range of punishment for a third-degree felony is 2 years to 10 years in the state penitentiary, a fine up to $10,000. And the lowest felony is a state jail felony. The range of punishment for a state jail felony is 6 months to 2 years in the state jail, a fine up to $10,000. Now, misdemeanor cases are divided into categories as well. There are 3 categories of misdemeanor. You have a class A misdemeanor, which is the highest, a class B misdemeanor, and a class C misdemeanor. The class C misdemeanors are cases that are normally filed in either the JP court or the justice court or the municipal court, which is the city court. The range of punishment for a class C misdemeanor is fine only. You can't get jail time, just a fine. Now, for example, not having a seatbelt is a class C misdemeanor. Speeding ticket is a class C misdemeanor, okay? The next highest misdemeanor is a class B misdemeanor. In this court, we handle class A and B misdemeanors. We only handle class C misdemeanors when they are appealed, meaning that somebody is found guilty in JP court or city court and they want an appeal, and so it comes to this court. The range of punishment doesn't change, it's still fine only. Now, a class B misdemeanor, the range of punishment is 0 days to 180 days, which is 6 months in the county jail, and or a fine from $0 to $2,000, or anywhere in between. Then you have a class A misdemeanor. The range of punishment for class A misdemeanor, if you're convicted, 0 days to 365 days in the county jail, which is a year, and or a fine from $0 to $4,000 or anywhere in between. Now, as a defendant in a criminal case, you have rights. Those rights are enumerated in the Constitution, also enumerated in our statutes, our codes of what we call criminal procedure, and penal codes. We have and the various different codes that deal with criminal cases. So one right that you have is you have a right to have an attorney. Right? That first document, which is titled Judge's Explanation of Rights to Defendants Without an Attorney, it reads as follows. As a defendant in a criminal case, you have 3 options. That's 3 options regarding an attorney. Number 1, you may hire an attorney. Number 2, If you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number three, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire an attorney, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case. Now, the prosecutor is the assistant district attorney that will be handling the case. So you cannot speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. The written waiver actually is on the second page. Now, you may not speak to the prosecutor. Well, be aware that there are dangers to self-representation. So there are dangers to representing yourself. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of the document, it states, defendant's choice. Mark initials next to only one choice. So if your choice is, I want to reset this case to hire my own attorney, then you will place your initials on the first line to the left. If you've already hired an attorney to represent you in this case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you will place your initials on the third line to the left. Now, if you've already been appointed a court-appointed attorney in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney, waiving your right is giving up your right to have an attorney, and represent myself, if that's your choice, if you want to represent yourself, waive your right to an attorney, then you'll put your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, you will sign on the line that's titled defendant. You sign your signature there, and you will place today's date, June 14th of 2022. Now, for those of you who will be waiving your right to an attorney and representing yourself, you would have to read and sign the next document. The next document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it states, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 14th day of June of 2022 by the County Court at Law number 2 of my rights to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, then you will sign on the line where it says defendant, and you will date it today's date, June 14th of 2022. Now, as a defendant in a criminal case, you have other rights. you have a right to have a trial by jury. Where that young lady is sitting in the area over there, we call that the jury box. 6 citizens from Jefferson County will be selected to sit on your case. They will listen to all of the evidence that's presented, and then they will deliberate, and then they'll decide whether or not you are guilty or innocent. You also have a right to waive your right to have a trial by jury, which means to give up your right to have a trial by jury. And by doing so, your case will come before the court. Now, your case will come before the court or before the judge in one of 3 ways. One way that it may come before the court is by way of what we call an agreed plea bargain. Okay. A plea bargain is an agreement that you make or you work out with the assistant district attorney in your case to settle your case. If you have an agreement, we call that agreement to settle your case. We call that an agreed plea bargain agreement. And then so if you worked out a settlement on your case, you have come to an agreement at what the punishment will be, then the case will come before the judge. Now, the judge can either accept or reject the plea bargain agreement. If the court or if the judge rejects the plea bargain agreement, then you will be entitled to withdraw your plea, which means you'll be entitled to take back your plea. And then you can start from, I guess, square one. But you'll be entitled to withdraw your plea. Now, if the judge follows the plea bargain agreement, then if you decide within 30 days of entering a plea that you would like to appeal your case, you filed an appeal, or you want to file an appeal, you have to first get the judge permission if he followed the plea bargain agreement. Now, if the judge gives you permission to appeal your case will be appealed up to the Ninth Court of Appeals. Now, an appeal is you would like to have a higher court to look at your case to see whether or not you've been wrongfully convicted or whether or not we committed an error by convicting you. And it will go right upstairs, right above us is a court up there called the Ninth Court of Appeals. And the justices on the Ninth Court of Appeals, they will review the case. They will decide whether to grant or deny your appeal. If they grant your appeal, they could either find you not guilty, or they could send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas. You will have to file what is called a pro se petition for discretionary review. Pro se means on your own. You would not be having an attorney represent you. We call that pro se. So you'll be filing this petition to the Texas Court of Criminal Appeals located in Austin, Texas, asking them to review your case to see whether or not your appeal should have been granted, whether or not you've been wrongfully convicted, or whether or not this court committed an error by convicting you. Now, they could either grant or deny your pro se petition. If they grant your pro se petition, they can just simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your pro se petition, at that point, then your conviction will stand. All right. Now, I stated that there are 3 ways once you waive your right to have a trial by jury, 3 ways that it will come before the court. One is by way of an agreed plea bargain. The other way, second way, is by way of an unagreed plea bargain. In essence, you and the state or you and your attorney has talked to the state and y'all don't agree, y'all can't come to an agreement, but you still want to plead either guilty or no contest on your case, and you want your case to come before the judge. We call that an unagreed plea bargain, and the judge will decide what your punishment will be, okay? Now, the third way your case can come before the court is by way of a bench trial. And what I mean by a bench trial is a trial without a jury. It's just a trial before the judge The judge will listen to the evidence and the judge will decide whether or not you're guilty or innocent after listening to all the evidence in the case. And if the judge finds you not guilty, you're free to go. The judge finds you guilty, the judge will assess the punishment. Now, you also have a right to have witnesses to come to court. The chair over there where that microphone is, we call that the witness stand. And what witnesses do, they'll come to court, they can testify either for you or against you. Now, you have a right to waive or give up your right to have witnesses to come to court. That means you have a right not to call any witnesses. And just because you do not call any witnesses does not mean that the state will not call witnesses. They will call witnesses to try to prove up their case. Now, you also have a right against Fifth Amendment right against self-incrimination. That means you have a right not to testify in your case. The state can't force you to take the witness stand. Nobody can force you to take the witness stand. You have a Fifth Amendment right in the United States Constitution not to testify in your case. Now, you have a right to waive that right to testify or give up that right to testify. And by waiving your Fifth Amendment right, you will be testifying in your case. You also have a right to have what we call discovery. That simply means you have a right to see the evidence that the state has against you before you either go to trial. So you have a right to see the documents, witness statements, objects, videos, tape recorders, or whatever evidence that they have. You have a right to have access to that. Now, you can waive your right to have access to them. By doing so, you're telling the court that you do not want to have access to the evidence that the state has against you. Now, everyone in here is out on bond. You're either on a cash bond, well, you're either out on a PR bond, a cash bond, or a surety bond. A PR bond is just, well, you're under your own personal recognizance. That's what you didn't have to pay any money to get out of jail. They release you, or you paid cash, the full amount of the bond, and you got out on a cash bond. Or you got a bondsman, we call that a surety bond, and you paying a bondsman. So you're out on bond. So I've said that to say this. That means that you were in jail. Every day that you spent in jail, that can be used as credit toward your punishment. So for example, let's say you spent 5 days in jail. And let's say the state is offering you to settle your case 5 days in jail. That simply means that you will not have to serve any more time in jail because the 5 days in jail will be given to you as credit for time served. Now, if you serve 5 days in jail and they're offering 7 days in jail, that means you would have to do 2 days in jail because you're going to get credit for the 5 that you spent in jail. Now, let's say the state is offering you fine and court costs. Now, every day that you spent in jail, you get credit at $100 per day that can go toward your fine and court costs. So you spent 5 days in jail, that's $500. So if the state is offering you fine and court costs of $500, that means you won't have to pay the $500. Why? Because the 5 days that you spent in jail has already paid it off. Therefore, you'll be given, your fine and court costs will be taxed and retired. You won't have to pay it. Now, if they're offering fine and court costs of $700 and you stay 5 days in jail, that means you would have to pay $200. Now, if you can't pay the $200 on the day that you dispose of your case, we can allow you to pay it in installments, and that's when we can put you on a payment plan. But let's say even if you put on a payment plan, you can't pay it at all. You still can't pay it because you don't have the income, you don't have the money. No problem, because the law allows the court to convert your fine and court costs to community service, which means you can work it off, and every hour of community service that you do at a nonprofit organization, you will get $12.50 that will go towards your fine and court costs. So for example, if you worked an 8-hour day at a nonprofit organization, that's $100. And so $100 will go towards your fine and court costs. Now, the other thing is Jefferson County has a program for first-time offenders. If you've never been in trouble before, Jefferson County DA's office has a program that is called pretrial diversion. With pretrial diversion, what they do, you get in the program, they dismiss your case. And once they dismiss your case, you complete the program, you can get it expunged from your record. Expunged means wiped off, deleted, or erased from your criminal record, right? You won't have a criminal record. And so in order to get into the program, one, it has to be your first case. You can't have a criminal history. Two, it cannot be an offense involving resisting arrest or unlawfully carrying a weapon. And three, you have to get the assistance of an attorney to get you into the program, okay? Now, if you are a veteran of any one of the branches of the United States military, Jefferson County has another program that's called Veterans Court. It is a pretrial, it's part of the pretrial diversion program, which means you get into the program, the case is, you complete the program, case is dismissed, you can get it expunged, which means deleted, erased, wiped off from your criminal history. Only criteria is you have to be a veteran. Okay, I don't think it have any limits as to what case you have, but it's the only criteria that I know of, you have to be a veteran of any one of the branches of the United States military, all right? Now, this court has a program that is called Community Safety Initiative, which stands for, it's the CSI program. That's a program that I started within the first 100 days of becoming judge here in County Court at Law Number 2. That program is designed to address the issue of what is called recidivism. Recidivism means when people commit crimes over and over. And so how do we stop that? Well, we have the Community Safety Initiative. That's a program that is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, go to church. Now, the way the program works is we have partnerships with local agencies. For example, the people that's sitting in the jury box, they're from Spindletop. Spindletop, they're from the Spindletop Center. Spindletop is our local mental health center. Now, with Spindletop, they can do private interviews, they can do an assessment, and they can develop a treatment plan, either outpatient or inpatient. Now, in order to be in the program, you don't have to be insane or incompetent. Spindletop are able to address issues such as anxiety, depression, bipolar, schizophrenia, post-traumatic stress, ADD, or whatever, a whole host of mental issues. They can address those issues. Now, also, Spindletop has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. Now, for individuals who have problems with drugs or alcohol, we have ATAR, and we also have the Alcohol and Drug Abuse Council that has a program that is called OZAR. OZAR stands for Outreach Screening and Assessment Referral. Basically, what these programs do is they can do a private screening, they can develop an assessment, they can do an assessment, and then you could be referred to a treatment plan, either outpatient or inpatient, to address either your drug or alcohol issues. If you are unemployed, do not have a job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Entrepreneurship, Commercialization and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. And what they'll do is once you get trained in one of the areas that you choose, then they will assist you at getting a job in that area. If you have not graduated from high school, you would like to get your high school diploma, they also have a program that is called, well, they also have a GED program where they can assist you at getting your GED. Now, all of these programs that I just mentioned to you, they are free. Doesn't cost you anything. Only thing you have to do, only qualification you have to have is a desire to be in the program. Now, all of these programs are, as I said earlier, was started in March of 2017. And these programs are unique to County Court at Law number 2. And I tell people this all the time. When you come to County Court at Law number 2, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in Jefferson County, and we're trying to make a difference in the lives of the individuals that come before this court. We do not just arrest the problem, we address the problem. We don't just give time, we take our time. And so with the program is designed to produce productive people. And we believe that if you produce productive people for the most part would not commit crimes. Why? Because they have too much to lose. And so if you're interested in those programs, just let us know. We have brochures and we have handouts that we can give you to get started in these programs. And as stated earlier, all of these programs are free, does not cost you or the county 1 cent. Now, at this time, we're going to have Deputy Hinton, who is our mental health officer here, to come before you and tell you something about the program that Spindletop have to offer. At this time, I'll present to you Deputy Hinton.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state and commissioned by the sheriff's office here. I'm here with my partner, Sarah. Now, Sarah is a qualified mental health professional with Spindletop. And the reason we're here today is because the judge cares about every single person that comes before his bench with legal issues. Now, what the judge has found is those who appear before his bench commonly have mental health or substance use disorders. If this applies to you, the judge believes if he can help you with these underlying issues, he can get you out of the cycle of arrest. Now, maybe this is your first time to be here, maybe it's your 10th time to be here, there's still hope. We actually have a system in place where we can connect you to resources. We can talk to you individually. We can find out exactly what's going on with you in your particular situation so we can connect you with the appropriate resources to help you with whatever issues that you may be dealing with. At the very least, I have a flyer here. It tells you a little bit about what we do here in the court on the back side. But on the front side, there's a 1-800 number. It is a crisis hotline number. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. Everything that you tell us today is HIPAA regulated. It is private. We will not share it outside of your presence or outside of your permission, but we will if y'all allow us to, if it benefits y'all. But we're here to advocate for y'all. That's our goal, to help you with whatever that looks like. Today, we can visit with you privately in the jury room if you wish to do that. If you don't wish to do that, if you'll provide your number and everything on the document that we've already provided on the clipboard, we will call you back and we will follow up with you and see what we can do providing resources. Like the judge said, it can be job related, it can be reference to general anxiety disorders. You don't have to be crazy to participate and take advantage of resources that are out there that are available for you. Does anyone have any questions? Thank y'all very much. We'll be visiting with y'all as the court goes into recess, and I will be getting this in everyone's hands, and then we'll be picking up those documents as well. Thank you, Your Honor.
Okay, thank you, Deputy Hinton. Now, ladies and gentlemen, make sure that the documents that you have in your hand is filled out. Now, if you need assistance with filling out the documents, we have personnel in the court that will provide assistance to you, and they're going to come around to you and pick up that paperwork. And it's going to take us a little time to get through this here, but once we get the paperwork, then we're going to call you up to the bench one at a time. So at this time, the court will be in recess. I'm gonna have to reset Mr. Leday. Mr. Leday, that's on Zoom.
Yes, sir.
Okay, now, Mr. Leday, what we're gonna have to do, there's some paperwork that needs to be filled out. And so you're gonna have to be here in person. And so what we're gonna do, we're gonna reset your case to give you an opportunity to appear here in person so that we can get the necessary paperwork filled out. Okay?
Yes, sir.
Okay. Give us a yes. Which one? Okay, your case, Mr. Leday, is going to be reduced, is going to be reset to July 29th of 2022, okay? at 9 a.m.
Okay.
All right, so you're free to go, and you have a blessed day.
You too, Your Honor. You have a blessed day as well.
All right, you're welcome.